withhold assent therefrom. But the argument is he can still withhold dissent, and further, that he can send it again to the president. It can't be done. There is no choice. But once the legislature sends it back, he shall not withhold assent. There is no choice. Likewise, if a bill derogates from the powers of the High Court, governor shall not assent, but must reserve it for the president's consideration. In neither situation is the governor exercising discretion. He's only following the mandate of 200. Regarding the first proviso, 200 as separate from the substantive part creates an absurdity regarding money bills. That's something that your lordships mentioned. That if he can withhold assent, he can also withhold assent on the money bill. Because that's part of the proviso. But that will be an anomalous situation. So, therefore, I'll skip this, Mullah. Then Article 200 cannot be read in a manner to create constitutional impasses and litigation between constitutional functionaries. You can't interpret the Constitution in a manner that will create more litigation. But personally, I think that 361 has not been accurately or constitutionally interpreted in the context in which it should be read. Otherwise, Mullahs, you'll make 200 unworkable completely. The sequitur of giving governor the power to reject a bill will inevitably lead to litigation between the state legislature and the governor, as it has, embroiling the executive and the legislature in protracted conflict, thereby paralyzing governance and defeating the spirit of parliamentary democracy. Conjured facts have no relevance to the issue at hand, Mullahs. All these facts that my learned friend mentioned, if he deals with foreign affairs, if the legislature deals, these are all conjured facts. And your lordship should not even look at it. You will decide a matter which is before you, not in the area of any situation which is a chimera, which has no relevance to reality, and you just conjure up something. I mean, legislatures, if you say the governor acts on the presumption that he is the highest executive authority and therefore acts with responsibility, the same assumption must be made in the case of the legislature, that they are acting with responsibility. Then, Mullahs, in conclusion, para 29, in conclusion, an interpretation that gives the governor the executive power to withhold assent upends the entire constitutional scheme. The union's argument of separating the substantive part of 200 from the proviso allows the governor to avoid communication, bypassing reasoning, and ignore the primacy of the legislature, all while acting on his own and being immune from judicial review. This creates a one-time, first-instance veto, which is free from any kind of accountability. Such an interpretation builds a super-constitutional office wholly incompatible with constitutionalism, responsible government, and democracy. Then, Mullahs, comes the timeline issue now. So, no more than 6 months, within 3 months, forthwith. Now it's the architecture that you create, which will be the law. And according to me, the following. All this confabulation must happen before the bill is proposed. Any problem that he has, I'm not giving a solution, any problem that he has must be communicated before. And once the bill is sent to him, he must assent. Right. There may be an extraordinary situation that may happen. I'll accept that there may be some situation where he still feels that he refers it to the president. Fine. But as soon as possible, forthwith must apply to the governor, must also apply to the president, because the president acts on the aid and advice of the Council of Ministers. So it's the government of India. It's not the president. So the same, what should I say, necessity of incorporating the concept of immediacy must be engrafted in the action of the president once the bill is sent to him, for he has to send it back And if it's passed again, he can't say no. That's how the Constitution will work. Otherwise, it won't work.
There is a qualitative difference in Article 201 later part
I know.
as against the earlier
Correct.
article.
Correct.
It shall be presented to the president.
For consideration. But it doesn't matter, let's create the government of India.
No, I'm saying that he must grant assent is what you say.
No, true, but I'm saying that. Supposing your lordships were to say he need not grant assent, you create the problem. Well, ultimately, you will have to decide how it works. Let's assume your lordship's thinking, let's take it forward. That he keeps it with himself. He doesn't respond at all. So the will of the sovereign legislature.
Founding. They are talking about a solution. Are we saying that the Constitution compels that bills need to be assented?
Yes. Yes, absolutely.
It's like that.
Yes. No, I agree. That's my constitutional premise.
Doesn't contemplate a situation.
Yes.
Where a legislature passes a bill.
Yes.
And it is not assented to.
By the executive.
President, you're talking about.
The president is the executive. Because he acts on the aid and advice of council.
Analysis. From the legislature, it goes to the governor.
Yes.
It could go back to the legislature.
Yes.
Then it comes back to the governor. Then first hurdle is that after that he can't refer it to the president. That's what. After he can't refer to the president, that also we need to find the textual requirement for that. And if it is permissible for him to send it, or even in the first instance, then the president considers, that's it. Constitutional text doesn't say that after his consideration.
Correct.
Why is it that specifically it is chosen? So therefore, as a court, we need to supply those words.
Yes, yes.
Saying that the president has no option but to assent.
Correct.
You want us to supply this?
Yes, yes, absolutely. Because that's the entire Constitution.
In the context of the larger principle of parliamentary democracy, federalism and separation.
Absolutely, absolutely. But the consequences would be disastrous. Point is, you are now a Hobson's choice.
So the Constitution has not contemplated a situation where under the federalism, the union can not assent to a bill.
Yes.
To stop.
Yes. They will be challenged if ultimately, and your lordships will decide whether it was right or wrong. But he cannot say no. That's the only way the Constitution will work. Won't work otherwise.
11 LD.
It's the same. The same. But the point is, that's what I said.
11.
Exactly the same. So you can't have two different yardsticks. Otherwise, what happens, Manoj? The executive exercises a power to overrule the will of the people, whether it's in the state or parliament.
No, but Mr. Sibal, 111 end and 201 end are different. They are not the same.
Shall not withhold a sentence.
No, then it is only sent for his consideration. What does that mean?
But naturally, Manoj, I'll tell your lordship. Your lordship is right.
Why it could have been said the same language as 111?
If it shall not withhold assent as far as 111 is concerned, will you read into the Constitution that he can withhold assent?
That's what we're trying to find out.
Well, therefore,
why the language is differently used?
Well, that's because nobody ever, when they framed the Constitution, imagined that this would happen. It has not happened till 2022. Since 1950, it has not happened till 2022. This issue has not come up before. That's why you should not intervene.
Yes.
Well, ultimately, your lordships will, let's assume now that the fact that it says it for the consideration of the president, there is an element of space within the government of India can say no. Let's accept that. What's the consequence? Litigation. So to that extent, the bill will never see the light of day till it is decided up to this court. Does the Constitution contemplate a situation like that? It's the question your lordships will have to ask. And if it does, fine, Mullah. I only think it will create a lot of litigation for us.
Good for the bar.
Good for the bar. Correct. Very sad for the people of India.
Not good for the country.
I mean, constitutional provisions can't be interpreted in this fashion, according to me. It's a living document. It has energy. It has vivaciousness. It deals with situations that we see today, propping up problems of governance, which we have never seen before. You have to resolve it constitutionally, not over cups of tea. Yeah.
This last question. Why so? The earlier question, when it goes back
Yes.
from the governor to the assembly, and
Yeah.
the assembly sends it back.
Yes.
The second stage, what is there in the constitutional text to prevent the governor from referring it to the president?
Yes.
First, from the text of the theoretical
Yes,
or a principle,
Yes.
as a value of the democracy,
Right.
is all right.
Right.
But from the text, is there anything
Correct.
that when it comes back to him after his message, what is there in the text to prevent him from not referring to the president?
The text says he has to accept it.
When it comes back,
It says he shall not withhold assent therefrom. Therefore, he cannot withhold assent.
it doesn't say that it will have to be.
This is the only option. He has to withhold assent. He cannot withhold assent. That's what the Constitution
The
says.
later part you're saying. You're saying for the reason that the governor shall
Reconsider the bill accordingly, and if the bill is passed again, with or without amendment, and presented
You're
to the
saying that the later portion will give the meaning.
Yes. Yes, exactly. Right. Therefore, Maharaj, as far as the governor is concerned, he has to clear it. As far as the government of India is concerned, they need not clear it. Both are executive, Maharaj. No, it's difficult to contemplate that situation constitutionally. So the proposition has to be, he has to clear it. There is an element of immediacy, must be done forthwith. As soon as possible means if it's impossible, that impossibility cannot happen in a constitutionally run regime. There can be no impossibility in dealing with the bill. So must be forthwith. Not even 3 months. Forthwith. There's an immediacy to the will of a sovereign legislature. And if he doesn't do it, Maharaj, you will have to then, Maharaj, create an architecture for making sure that the will of the people is represented through the legal process. The will of the people can't be subject to executive whims and fancies. Yes, there's a very Now, but let's kindly come to Article 254(2). This is the issue of repugnancy, Maharaj. 254(2). My Lord, the Chief Justice has it.
Yes.
Which one?
254(2). If I may, let's read it. Where a law made by the legislature of a state with respect to one of the matters enumerated in the concurrent list, that's where the repugnancy issue comes up, Malas, contains any provision repugnant to the provisions of an earlier law made by Parliament or an existing law with respect to that matter, then the law so made by the legislature of such state shall, if it has been reserved for the consideration of the President and has received his assent, prevail in the state. Now the proviso, provided that nothing in this law shall prevent Parliament from enacting at any time any law with respect to the same matter, including a law adding to, amending, varying, or repealing the law so made by the legislature of the state. So, Parliament has a way out. If they think it's repugnant, they can immediately pass a law. No need to send it back. And no need to withhold it. There is a constitutionally provided solution.
Prevention is better than cure, no?
Yes, absolutely. So the point is, Mullahs, there is a constitutionally provided solution in case of repugnancy. This is just a bogey, Mullahs. It's to make sure that these bills of the states are never passed. It's a constitutional anachronism, Mullahs, to interpret the Constitution in this fashion.
But it is in the context of your argument that bills which do not enjoy legislative competence, knowing very well when they are passed, though 254 applies, but nevertheless they need to be assented.
Yes. Yes, yes, absolutely.
So it's only in the later part
That's right.
that the court might set aside.
Correct? Absolutely.
But then the bills need to be passed.
That's right. Well, that's the will of the legislature. Well, it's sovereign. You can't have the executive becoming an impediment in the will of the people.
Theoretically, not
Yes,
that the state was going to
correct.
do it.
Not that they are, Manas. We are not. We're answering a question or of a reference. Therefore, I'm saying
A state's bill on citizenship
yes.
can't be stopped even by the president.
No, you're assuming now, Manas. That's
Theoretically.
no, you can't, Manas. I'm sorry, Manas. I'm sorry.
Theoretically. That's
No. Then I'll take other facts, Manas, theoretically, which will destroy the argument, Manas. What's the
your argument that it could be tested only in a court.
no, Manas? Your Lordship is assuming that there will be a state legislature in this country. Manas,
That it will not be in a situation.
Manas,
Gave you an extreme example.
but that extreme example should not lay down. As somebody said, bad examples like bad law, Manas. Well, my Lord differed with that. And
Hard cases make good law.
that's right.
Yes.
So, Manas, these are assumptions made that they will pass a law in respect of foreign affairs and then an argument is made.
So true.
If we are not going to deal with facts, then we cannot deal with these assumptions. When that issue comes up before your lordships, you will deal with it. But you can't deal with it in a reference without the fact. Because you are now assuming something. They say, don't refer to what West Bengal did, don't refer to what Tamil Nadu did, don't refer to these facts, but refer to my facts. Can't have it both ways. Though I accept what my Lord is saying, Malas, but that's not something that's going to happen.
You ask a question, it's intended for the interpretative.
I understand.
That's-
The interpretation is very simple. I mean, that's a constitutional thread that runs through the Constitution.
All of us are well trained, so don't get upset.
Executive barred from interfering in the process of legislation. Constitutional bar. Therefore, this whole question about I'll have to file a writ petition and the governor will, it's all irrelevant. None of this should happen. Should be done forthwith. Only question will, even after it is sent by the legislature back, he still withholds it. Then what happens? That's the only area where your lordship will actually have to lay down. Now, whether it's deemed to be passed or what procedure you will create for the insurance to ensure that the will of the people is carried forward, is you'll have to create that. I can't provide a solution for that. But remember one thing. Do not allow, as a matter of constitutional law, the executive to interfere in the will of the people. That's all. Whereas theoretically, has any parliamentary legislation passed a law violating list 2? No. So if they do pass a law, what happens?
But Mr. Simple, examining, let us say academically, there is no instance. The power of parliament under proviso 254(2) is not a substitute or is not to render the power of the governor to reserve a bill for the presidential assent as redundant.
You're right.
Those two powers are independent and they will coexist.
Exactly. No, I agree. I agree entirely.
There can be an example, say the governor may assent to a bill and that will become act. But in due course of passage of time, the parliament may experience that one of the provision of that act is repugnant. And therefore, the
Proviso comes in.
amendment is asked.
Correct.
That to that
Absolutely right. I entirely agree.
they find
Correct.
that it may create
Absolutely right. But that can happen at any stage. It can happen earlier also. It can happen straight away when the bill is sent and they feel that there's a problem and there's a problem of repugnancy, they can pass a law. So it can happen, but there's a solution provided in the Constitution. But that solution is not that I sit on it and not give assent to it. And that's true of everything but Manoj, the other thing that I wish to say, and I say it a little later, I'll try and finish by...
in other words, the proviso under 254(2)
Yes.
is a second filter.
Yes.
That if a mistake is committed there,
Yes.
Parliament still enjoys that,
Exactly.
that power. Okay.
Exactly. That's my submission, Manoj. Now, let's kindly come to 34. So, basically 34 and 35, that the decisions must be taken forthwith. There is no question of 3 months, 6 months, 6 weeks, forthwith. Unless it's impossible, because that's as soon as possible. Right, Manoj? And 36 says, the words as soon as possible in 200 refer to the hiatus between the presentation of the bill and its return for reconsideration by the legislature. Whereas what happens is there are a couple of stages here. Number one, you send the bill, he doesn't deal with it. So what happens to as soon as possible then? He just doesn't deal with it. And that's not hypothetical. So as soon as possible has no meaning. So he has to deal with it, and he has to deal with it forthwith. And he has to send it back. And the processes should be completed in under 167. And then there can be no impediment. If they are not completed, even then, he must forthwith send it back, whatever his comments are. Or forthwith send it to the president. He can't delay that also. Supposing he says, I'm sending it to the president, but I'll take 2 years to do that. He can't do that. So that your lordships will have to clarify as a matter of constitutional law. And if it reaches the president, the government of India must forthwith send it back with whatever comments they have. And we need not have to litigate on that. Once the declaration of the law is there, there'll be no litigation. Then come to Mullah 36. The words "as soon as possible" in 200 refer to the hiatus between the presentation of the bill and its return for reconsideration by the legislature. This phrase barely recognizes that some additional time may be needed when the governor chooses to withhold assent and send the bill back, and requires that even this be done with the greatest expediency. This absence of words as soon as possible in the substantive part does not permit endless deliberation. It indicates an inbuilt constitutional mandate that the decision to assent, withhold, or reserve must be taken even faster as soon as possible, that is, forthwith. The Constituent Assembly originally provided, well, as your lordship has that, 6 weeks and all, no repetition. Then, well, let's come to the another argument made, which is judicially manageable standard. He said, look, there are no judicially manageable standards. If he withholds the bill, how are you going to decide whether he's right or wrong? There are no judicially manageable standards. But the concept of judicially manageable standards is not a matter of constitutional law at all. Well, it's directive principles of state policy. What your lordship says, these are the judicially manageable standards. How do we implement that? That's for the state to decide. Comes to equality, you say, we'll decide. All of part 4, duties of citizens towards the state, not judicially manageable. Because that's in the area of either policy or in the area that if there is a rule of evidence that in the absence of facts, you cannot do anything. I must pay allegiance to the Union of India. It's a duty, not judicially manageable. But that's nothing to do with 200. So para 39, first, once it is accepted that the governor does not enjoy an untrammeled power to withhold assent, the natural sequitur is that his decision must be taken within a reasonable time frame to reject the notion of an absolute veto while simultaneously holding that the courts cannot prescribe and enforce a timeline is to create a constitutional absurdity. It would amount to allowing the governor to sit on a bill indefinitely, thereby achieving through delay the very outcome of which the Constitution prohibits. So if you say, okay, he cannot withhold a bill, but you say that no, he can sit. When I send the bill to him, he can sit, Mullahs. That is also amounts to withholding the bill. If you reject that argument, you'll have to reject this. You can't have through an interpretive process the same outcome of withholding a bill because there's no timeline to be adhered to. So the timelines required are integrally linked to the process of immediacy and cannot be allowed to result in withholding the bill. It becomes clear when one considers the 3 stages to the time frame. When a bill is presented, the requirement as soon as possible demands that assent, withholding, or reservation be declared forthwith. If the governor fails to act, the court cannot prescribe a time frame. It is equivalent to conferring an indefinite veto. Because if you don't have a time frame, there will be a veto. 2, when a bill is returned to the legislature and comes back, Article 200 says governor shall not withhold assent. If no timeline can be enforced, the bill once again becomes again a veto. So the very malaise that you tried to prevent exists in not having a timeline. But it will amount to withholding. C, where a bill is reserved for the president, and that too must be done forthwith. If the governor chooses not to send it and the courts are powerless to intervene, it is nothing but a disguised power to withhold. So you come back to the same question. All right, don't give me the power to withhold, but don't give a timeline which will result in withholding. Cannot be, this cannot be a principle of constitutional law. So there are judicially manageable standards which are part of Article 200. are integrated into 200. And immediacy, forthwith, as soon as possible, without delay, is part of the constitutional structure. So there's no question of judicially manageable standards. Then come to 44 straight away. Thus, time limits prescribed by constitutional courts under the circumstances above are not to be equated with judicially enacted constitutional amendments. He said, well, the argument was that, look, if you give a timeline, you're amending the article. Of course not. You're ensuring that the article functions, that the constitutional machinery functions, not that you're amending it. It's an issue. As recognized in, let's leave that out. Then 545 minutes. There is no automatic or self-executing consequence to crossing the time limit. It simply triggers judicial scrutiny. A timeline set by this court does not mean that the governor is mechanically bound to act within 1, 2, or 3 months in all cases. Rather, it means beyond the prescribed period. If an objection is raised, the governor or the executive as whole must satisfy the court that the delay was justified and free from abuse. Quite frankly, Maharaj, this is not relevant because that's not my argument. This is what the Tamil Nadu judgment says. Now, Maharaj, kindly see para 46. That's very important, Maharaj. The timelines prescribed by this honorable court are also based on the following. Maharaj, Tamil Nadu provided some timelines, but based on what? Office Memorandum of the Ministry of Home Affairs, Government of India, dated February 4, 2016, issued to all ministries and departments of the government, acknowledging the undue delay in clearing reserved bills despite an earlier guideline of 22nd September 92. The memorandum thus admits that decisions on reserved bills must be taken expeditiously. That's the memorandum on which was Tamil Nadu relied. Well, that's the constitutional purpose. Sarkaria Commission, Punchi Commission, both recommended timelines. I'm not on timelines at all, Malas. My argument is different. You give them timelines, they breach the timelines, you destroy the constitutional working of the Constitution. Then, Malas, judicial review. You want me to read it? Not necessary. I've already made the argument. Yes, yes. Then you come to
131.
No, kindly come to para 52, Maharaj. Para 52. Because my learned friend talked about justiciability. He said, it is not justiciable. It's not question of judicial review doesn't arise. Well, let's kindly see para 52. An absence of judicial review may be presumed in areas such as fundamental duties under Part 4A of the Constitution and broad economic policy. These are rules of evidence. You don't have the facts. Further, matters relating to relationships of confidence, which are protected by the concept of privileged communications, are not matters for judicial review. This is based on the principle that the rule of evidence does not allow them to be matters for judicial determination. Because you just don't have the facts. Similarly, acts of the executive in which law and order is required to be maintained in respect of in situ situations are again not matters for judicial review. 371A, 371H. This is reflected in the discretionary actions of the governor under 371A, which are pure executive actions and cannot be regulated through judicial determination. However, the principle does not apply to specified constitutional obligations of either the executive or the legislature. Well, another argument was made, see, you have timelines. Wherever the Constitution wants timelines to be provided, they are provided, but all of them are legislative. There will be a 5-year term of the Assembly. There's a 5-year term of Parliament. That's the bedrock of democracy, timelines in respect of legislation. Elections will be held in such and such time, within 6 months of the Assembly being dissolved. This is not in the functioning of the executive. If there exists a provision, the contours of which are clearly established, within which the executive or the legislature is to function, and which impacts Part 3 of the Constitution, or is reflected in constitutional provisions delineating the powers and responsibilities of the constitutional authorities, then such action is subject to judicial review and is justiciable. Article 200 is one such provision. It is not a provision that requires the governor to be satisfied, as in the case of 356. Therefore, the question of justiciability does not even arise. Thus, Article 200 is within the powers of the court's judicial review. Then, Malad's judicial review is invited the moment he kindly come straight away to 59 now. Oh, sorry, what? 59, yes. Now, Malad's 59 is Rameshwar Prasad, right? This is page 908. Malas, if I may, Malas, just read 361 with you again, Malas, if your lordship permits me, just so that we clarify the contours of 361.
Yes, sir.
The president or the governor or Raj Pramukh of a state shall not be answerable to any court for the exercise and performance of powers and duties of his office, or for any act done or purporting to be done in the exercise and performance of those powers and duties, provided that the conduct of the president may be brought under review by any court, tribunal, or body appointed or designated by either House of Parliament for the investigation of a charge under 61, provided further that nothing in this clause shall be construed as restricting the right of any person to bring appropriate proceeding against the government of India or the government of a state. Just pause here. If you allow the governor the personal power to take a decision, neither the government of India nor the government of the state is involved. How will 361 apply when it's the decision of the governor that I will not give you assent, or that I'm keeping the bill pending? Government of India can't defend him. Government of a state is at odds with him. So how will a writ petition lie? You can't interpret 361 in this fashion. If you give that power to the governor, my argument is that you should not do so. But if you do give that power, then he's answerable. Then 361 will not stand in the way. You can't have it both ways. You take recourse to 361 saying he's not answerable, and you give him the power under 200, and you say governor will not file an affidavit, and court can't issue a process. Then you're making the Constitution unworkable. Because that's the only act in which he is not accountable. There is no act in the Constitution which makes the executive not accountable to the court. But this is a provision where you will give that. You can't have an absence of accountability as a constitutional provision. Therefore, mothers, that's why I've been saying time and again, the governor has no such power. This situation should not arise, should not be allowed to arise, is not constitutionally permissible. He has to give assent. The president has to give assent. And litigation will take its course, whether it is repugnant, not repugnant, whether it violated a constitutional right of citizens, did not violate, whether it's whether the legislature had the capacity to enact the law. These are situations that would arise in the course of litigation, and you will decide. But he has no power not to assent. Only question your lordships have to do, if despite that he does, then what's the remedy? That's the only area where you have to create an architecture for a remedy. Either deemed assent or some other thing. Just wanted to flag that issue for your lordship's consideration. Then, really, Rameshwar doesn't answer that question. I'm just, since your lordship said, doesn't answer that question. Because, again, the problem that with us lawyers is the following, and I must concede that we are guilty of that. We take out a sentence from one judgment and we say that it's the exposition of the law, realizing that every judgment is contextual, arises from the facts of the case, has no bearing on another issue, where the facts are not before you. And there are very famous words. It's not part, but we've handed over a hard copy. Just have a look at that since I just finished this aspect. This is an Oriental Insurance Company versus Rajkumari. Para 11. Just give the judgment, please. I'm sorry, but we'll put it in the... $25, okay.
So read 11 and 12.
Yes. Yeah. It's here. Yeah, this judgment at page 1146, on the left-hand side top, at the bottom, paragraph 11. 1146, paragraph 11. At the bottom, if I may read. Reliance on the decision without looking into the factual background of the case before it is clearly impermissible. A decision is a precedent on its own facts. Each case represents its own features. It is not everything said by a judge while giving a judgment that constitutes a precedent. The only thing in a judge's decision binding a party is the principle upon which the case is decided. And for this reason, it is important to analyze a decision and isolate it from the ratio decidendi. According to well-settled theory of...
Said in Dhanvantari Devi.
Yes, exactly. That's why, in the 2G case, when auction was prescribed for telecom, in the telecom sector for spectrum, the question arose, does it apply in every other case? And your lordship said, well, as far as spectrum is concerned, it's fine, but it can't apply to other cases because the fact situation is different. So, how can a principle of law, so in Nambudiri, for example, it was said that the House stood dissolved, the Assembly stood dissolved, and the matter was pending before the President. And since there was no timeline, even if the Assembly is dissolved, the bill can be passed. Right, Manas? That's what Nambudiri says. The argument is the court has said no timelines. Therefore, no timelines in 200. What's the relevance of that to what we're discussing today? So you can't take a judgment like that and set up a constitutional principle that no timelines will apply in 200. Well, that was not the issue before the court. The question is whether the bill survives or not, because it's awaiting the consent of the President, and the court said it survives. That's the mistake we commit. So it says, Findings of material facts direct an inferential finding of facts is the inference which the judge draws from the direct or perceptible facts. Statements of principles of law applicable to legal problems disclosed by the facts. Judgment based on combined effect of the above. A decision is an authority for what it actually decides. What is of essence is that in a decision is its ratio, and not every observation found therein, nor would logically flow from the various observations made in the judgment. The enunciation of the reason or principle on which a question before a court has been decided is alone a binding precedent. Case is a precedent and binding for what it explicitly decides, and no more. And this goes on, Mullah. Courts should not place reliance on decisions without discussing as to how the factual situation fits in, that's para 12, with the fact situation of the decision on which reliance is placed. Observations of courts are neither to be read as Euclid.
That's what Dharmantari there is a
That's right.
slight distinction in fact.
That's right. So let's not.
With application of the same law,
Yes.
will lead to divergent results.
Correct. So you can't apply 356 to 200. You can't apply Nambudiri to this. You can't apply Veluri to this. Then, Mullah, this is at 909, para 60. Mullah, I've done my argument on 361 already, so I will not read it, Mullah. It only talks of 361. Then comes, Mullah, the 131 and 132. Now, Mullah, before that, Mullah, kindly come to an issue that I wish to raise, not on maintainability, but kindly have a look at, where's that table? No, the table where, previous table. Yes. Annexure A, page 911, Mullah. Now, Mullah, I have set out here all references made in the past. All references. And no reference in the past is similar to this one, because in each reference, there is a specific question asked. In each reference. I'm not on maintainability. But I would request your lordships to be careful when deciding a matter of this nature, dealing with a hypothetical situation in the absence of facts. What has been directly argued is that the governor has immunity, that he can withhold assent, that your lordships must answer. But there are several peripheral issues which are not before you. It's not on maintainability, it's the discretion of the court whether to answer all the questions or not to answer all the questions. Now kindly look at this chart at page 911. Delhi Laws Act 1912, in 1951, SCC 568. What is the question? Was Section 7 of the Delhi Laws Act or any other provisions thereof, and in what particular or particulars or the extent ultra vires the legislation? Direct question, Mullah, that your lordships had to answer on the light of the law that was operative. Then Kerala Education Bill, 1958 reference, does subclause 5 of 3 of Kerala Education Bill read with clause 36 violates, offends Article 14? Direct question. Come to Berubari Union, famous case, direct question. Kindly come to Sea Customs Act, 1963 Supreme Court. Direct, do the provisions of 289 of the Constitution preclude the Union? Direct question. Privilege immunities of state legislatures? Direct question. Presidential reference, 1974? Direct questions. Special bill, special courts bill? Direct question, whether the bill or provisions thereof, if enacted, would be constitutionally valid. In fact, Justice Chandrachud in this judgment, Senior Chandrachud said, that, look, even this is very vague. You should have told us which are the provisions that should be held to be invalid. The court is not here to tell you whether the court is not performing that exercise. You want to ask me a question, you ask me a question. I'll cite that just now. Kaveri water dispute, direct question. Ismail Faruqi, direct question. Special reference, 1998, direct question. Jammu Kashmir grant of permit of resettlement, direct question. Special reference 201, direct questions. Special reference 202, direct questions. Natural resources allocation, direct question. Tell me which reference has ever been made like this? You're asked to answer on all kinds of assumptions. All kinds of scenarios are put before you. Is that the duty of the court? To not conjure up scenarios and then answer a question? What will happen in 131? What will happen in 32? When it happens, then you'll answer that. You'll answer that through your judicial process. But you're not going to take examples like that and answer questions. It's the job of the government or the president in the reference to tell you, this is what we are troubled by. Does arise or likely to arise? How does Maharaj 131 likely to arise? Or 32 whether it lies or not likely to arise? How is it relevant? So Maharaj, now let's look at that. First of all, Maharaj, what Justice Chandrachud said in Rebel. That's which is that? Volume 9. Page 3685, PDF 184, para 30. This is where they said, you just tell us whether the bill is unconstitutional or not. What does Justice Chandrachud say?
Page number?
Page 3685, PDF 184, paragraph 30, volume 9. You just have it, Maharaj? My Lord Chandrachud. Where has it? May I read it, Maharaj? May I read it, Maharaj? We hope that in future, whenever a reference is made to this court under 143 of the Constitution, care will be taken to frame specific questions for the opinion of the court. Fortunately, it has been possible in the instant reference to consider specific questions as being comprehended within the terms of the reference. But the risk that a vague and general reference may be returned unanswered is real and ought to engage the attention of those whose duty it is to frame the reference. Were the bill not as short as it is, it would have been very difficult. It would have been difficult to infuse into the reference the comprehension of the 2 points mentioned by us above and which we propose to decide. A long bill would have presented to us a rambling task in the absence of reference on specific points, rendering it impossible to formulate succinctly the nature of the constitutional challenge to the provisions of the bill. And somewhere else it is said that it can't be hypothetical. Yes. Then Miller's para 26. This is very important. Para 26 at page 3684. The second objection, this is an objection to maintainability. I'm not on maintainability, Maharaj. We're beyond that. The second objection to maintainability of the reference is that it is vague, general, and of an omnibus nature. The question referred to by the President in this court is the following: whether the bill or any of the provisions thereof, if enacted, would be constitutionally valid. It is true that the reference does not specify with particularity the ground or grounds on which the bill or any provisions may be open to attack under the Constitution. It does not mention whether any doubt is entertained regarding the legislative competence of the Parliament to enact the bill, or whether it is apprehended that the bill, if enacted, would violate any of the fundamental rights, and if so, which particular fundamental right or rights. A reference in such broad and general terms is difficult to answer, because it gives no indication of the specific point or points on which the opinion of the court is sought. It is not proper or desirable that this court should be called upon to embark upon a roving inquiry into the constitutionality of a bill or an act. Such a course virtually necessitates the adoption of a process of elimination with regard to all reasonably conceivable challenges under the Constitution. It is not expected of us, while answering a reference under 143, to sit up and discover article by article which provision of the Constitution is most likely to be invoked for assailing the validity of the bill if it becomes law. The court should not be driven to imagine a challenge and save it or slay it on hypothetical considerations. Save it or slay it on hypothetical considerations. As observed in Hamilton, speculative opinions on hypothetical questions are worthless, and it is contrary to principle, inconvenient, and inexpedient that opinion should be given upon all such questions at all. It applies directly to this case.
Read 27.
We are at one stage of the arguments so much exercised over the undefined breadth of the reference that we were considering seriously whether the circumstances it was not advisable to return the reference unanswered. But the written briefs filed by the parties and the oral arguments advanced before us have, by their fullness and ability, helped to narrow down the legal controversy surrounding the bill and to crystallize the issues which arise for our consideration.
In
We
2G,
close to the-
in 2G, DK Jain explains
Yes,
what is to be done by a reference court
yeah,
when there is uncertainty about the
yes.
claim.
Now, if you look at the questions here, you are conjuring up issues, Manoj, which may never arise. Now, just look at the questions, Manoj. My iPad, yes. I'm not going to delve much on it, Manoj, just so that you have to, in ultimately deciding this matter, have to be careful where you want to give an opinion and where you don't want to give an opinion. Volume 3, Manoj. Page 7.
Volume 3, page,
Manoj.
3 page 7.
Page 7, Manoj.
PDF page 7?
Volume 3, page 7, Manoj.
Index of the
Index and documents, volume 3, Manoj. It's part of the
You come to volume 3.
volume 3, Manoj. Index of documents, volume 3, Manoj, page 7. It's now, as far as 1, 2, and 3 are concerned, they arise. Only they are specific.
Yes.
I have no problems with that. 1, 2, and 3. Though constitutionally, 1, 2, and 3, Manoj, whether constitutional options before a governor when bill is presented to him under 200. I mean, it's not in the context of any facts, Manoj, but let's assume, Manoj, that your lordships can consider reading 200 and answer that. Then is the governor bound by the aid and advice standard? Let's assume that. Is the exercise of constitutional discretion under 200 justiciable? Then Article 361 is an absolute bar. How does that arise? What's the relevance of that here? No such thing has happened. Why should you answer it? The absence of constitutionally prescribed time limit. Why do you assume that? You're going to interpret 200, interpret 200. You can't assume that there is no prescribed time limit. How do you assume that question? Assume that it requires to be decided. You interpret 200 in the matter that constitutionally, and then that will be the end of the matter. Why do you assume that there are no constitutionally prescribed limits? It's an assumption made, Mullahs. Can't be a question on an assumption in constitutional law. Is the exercise of constitutional discretion of the president, it's all part of 200. And that's not arisen in any situation, Mullahs. Kindly see. This question of 201 has not arisen in any situation. You're asked to answer the question. In a fact situation, if it arises, you will answer it. At the moment, it is obvious, Mullahs, and I can say it up front. It's obvious there's a judgment of this court and somebody wants to say that, no, that's not good. In the light of constitutional scheme governing the powers of the president, is the president required to seek advice of the Supreme Court by way of a reference? You're directly dealing with the judgment. If that arises, you decide it. But you're directly dealing with the judgment, which is prohibited, as you know. It will be challenged, Mullahs. I'm sure it will be challenged. You may set it aside. No problem. But this is no way, Mullahs, to get an answer. Are the decisions of the governor and the president at 201 justiciable at a stage anterior to the law? How is that? Is that arisen anywhere, Mullahs? Anterior to the law? Has it been said by any judge, Mullahs? Can the exercise of constitutional power and the orders by president be substituted in any manner under 142? It's not arisen. It has arisen in a particular context and the particular facts of a case which was rendered, on which a judgment has been rendered. You can't tangentially, Mullahs, attack the judgment in this manner. Yes, you can say that judgment is wrong and it will happen. It will happen one of these days in some other case. You go for review.